Veterans Legal Aid Group. So we are a zero net profit law firm, and we focus only on veterans disability law. So we don't do anything financial. We don't do estate planning or elder law. We only help folks get their VA benefits. And today I brought Dr. Glenn Osborne. He is our managing director, and he will be discussing the VA benefits, how they work, and what we can do to help you. Okay, so just an overview, and I will not read the slides word for word, but just kind of give you the gist of what the slides are talking about. So like I said, we are a zero net profit law firm focusing only on veterans disability law. So this is all we do. We've done this for quite some time, and we are in all 50 states. In most U.S. territories. We have clients in every state and even some overseas as well. We help with what's called service-connected disability compensation and non-service-connected disability pension, which is what most people refer to as aid and attendance. And the important thing to remember is that you cannot receive both benefits simultaneously. So you can only receive one or the other. But what we do is help you determine which benefit is best for you and which one you're most qualified for.
What we want you to take away from the very beginning of this is that the VA administers 2 disability programs. And why is, first of all, why is this even important, to be talking about? Well, it's real simple. As everybody I'm sure is aware, there are folks seeking assistance at assisted living, memory care, or any variation of those programs. It's financially challenging to some families. Either there's a limited amount of income to draw on, or there's a limited amount of assets to cover for a relatively short period of time. The whole point about why VA benefits are important is simply this. If a person is potentially eligible for one of these benefits, it can provide anywhere from 20 to over 50% of the monthly cost of living in assisted living or memory care. It's a tax-free benefit. So either it can make the difference in a person being able to afford the care that Vitality Communities offer, or if a person has limited assets and can only, let's say, for example, draw out of savings or what have you for 2 years. If they get the benefit, and the benefit then can provide, let's say, 40 to 50% of the cost per month of that room and the associated care with that room, then all of a sudden that 2 years just became 4 years. So it can make a huge difference in the ability of individuals to actually get the care they need. And going back to the beginning of who we are and what we do, we came out of the care business. I've got an executive director's license still. I ran communities. I've been a regional, a divisional manager. We started this firm because, and this was about 20 years ago, we saw the need for people to be able to get a clear, concise answer to what these benefits were, because trust me, there is a ton of misinformation out in the public domain about this. And we'll talk about some of that as we go. But they needed a clear answer, and they needed to know with a very high degree of certainty whether or not a loved one was potentially eligible for the benefit while they were making a decision on what type of care they were going to purchase, because that does make a huge difference. So our job is to help people understand what the evidence is all about, and to let them know whether potential eligibility exists and how much of a benefit they can anticipate getting to help pay the cost. So that's the reason we're here today, is to explain the benefits with the goal of it not just being an academic exercise saying, hey guys, here's a lot of information you need to know, but taking this information and using it in order to see if the VA can help absorb some of the cost of the care that an individual needs. So with that having been background, to recap what I'm sure Mary has covered so far real quick, is the VA administers two types of disability programs. Now, all of these benefits are under the umbrella of disability benefits. That's just the way the VA has them categorized. There's two families of benefits. There is service-connected disability compensation, which is what we're talking about right now. And there is another class of benefit, which we're going to get to in a minute, called non-service-connected disability pension. Now, everybody may be wondering this, but when are you going to talk about aid and attendance? Well, we're going to get to that in a minute. But just so that you know to begin with, there is no benefit directly that you can apply for called aid and attendance. There is a special additional monthly benefit that can be added to either service-connected disability compensation or the non-service-connected disability pension if you have the medical need for the help of other people. So all aid and attendance is an additional amount of money to be added to one of the basic programs. So you apply for compensation or you apply for pension, and then aid and attendance is just more money that you can potentially get if you have the medical need for the help of other people. So if you're wondering why we haven't mentioned aid and attendance, that's why. So we're going to talk about the two basic families of benefits. As we started out saying, service-connected compensation. Compensation is payable to a veteran who suffered a disability while they were on active duty. So that could be a wound, it could be illness, it could be an injury, it could be any number of things. It can either be an active incident. I was wounded, I fell down a ladder, I hurt my back, I was, or I got an illness while I was in service. Anything like that, that's a direct cause. There's also a big category called presumed causes. Now, there's several of those. As I was hearing Mary at the end there, if you were involved in the atomic bomb and hydrogen bomb testing out in the Southwest and the South Pacific, and you were exposed to ionizing radiation, you have cancer. That exposure to the radiation is presumed in law to be the cause of your cancer, so it is service-connected. The biggest one right now is if you were in Southeast Asia. If you were boots on the ground in Vietnam, or you were up to 12 nautical miles off the shore of Vietnam, then you are considered to have been presumed to the toxic defoliant Agent Orange. And there are 14 diseases that are associated with that particular benefit. For example, and they're very common: prostate cancer, diabetes type 2, Parkinson's disease, ischemic heart disease, I think I said Parkinson's, non-Hodgkin's lymphoma, Lou Gehrig's disease. If you have one of those and you were in Vietnam or you were close into the shore of Vietnam, up to 12 miles offshore, your disease was caused in law by exposure to Agent Orange. One of the newest ones is if you were at Camp Lejeune, North Carolina from the mid-50s to the mid-70s, and you drank the water at Camp Lejeune, and you have certain kinds of cancer. They were using catch basins for chemicals, and you were exposed to benzene, among other things. So one of the things we see a lot of are people who are at Camp Lejeune and now have Parkinson's disease. So that's an example of presumed cause. Now, for the spouses of veterans, as Mary was saying, if the veteran was 100% service-connected disabled for 10 years before they died, or the death of the veteran can be linked back to their service-connected disability, then there is a benefit called dependency indemnity compensation, which is a mouthful, so everybody calls it DIC, which can be paid to the widow. So the special aid and attendance benefit does apply in compensation cases. If the widow is looking at DIC, we can add the aid and attendance benefit. If the veteran is considered totally disabled due to their service-connected disability, we can add the special aid and attendance benefit. So the benefit for compensation is interesting in that there is no income or asset qualification. You could literally be making $10,000, $20,000 a month and have $1 million in the bank. It makes no difference because it was service connected. There's also no qualifying service periods. So as we're going to see in a minute, in the pension benefit, there is a qualification for when you served, but for service connected, it could be any time. Now, what we generally do in service connected cases is there's a lot of veterans who have a service connected disability and it's gotten worse over time, and they've never gone back to the VA and asked them to be re-examined and have their benefit increased. We do a lot of that. There's also a factor called individual unemployability. If you're 60 to 70% service-connected disabled and you're not able to hold a job because of your disability, the VA is obligated in law to rate you to 100% disability based on unemployability. So we do a lot of those cases. So service-connected is by far the largest of the two VA programs. It is not the one we do most work with. Okay, so here's kind of the summary. You got to have wartime military service. That's your military discharge papers. If you're married or you're the surviving spouse, we're going to have proof of the marriage or the fact that you were married at the time of the veteran's death. If we're going to apply for the aid and attendance special benefit, there's medical evidence that we'll get from your doctor. And then we have talked about net income and net assets rather exhaustively. So I trust that you have a basic understanding of what that's involved. So there's your 5 requirements that we have to prove. Okay. So now we're going to talk about door number 2. And this is the one that most people are interested in, and this is the one that most people would be applying for when they come to assisted livings. And that is the non-service connected disability pension. Now, understand the term pension does not mean military retirement. If you've ever gone on the internet and searched out information about these benefits, I'm sure you would probably nod your head up and down right now that there was a tremendous amount of information you got that was confusing or contradictory, and you're absolutely right. Whenever we talk to a new client or a potential family, one of the first things we do is take about 10 minutes and explain what you're actually talking about, what this is all about legally. And all of a sudden you can kind of see the light go on. It says, oh, okay, now I understand. Now it begins to make sense. So we think the more you know, the better sense it makes and the better you're able to understand what the process is. So pension has been used by the federal government for this particular kind of benefit ever since 1866. So it's not new by any stretch of the imagination. It's an old benefit. In its current iteration, it's been around since January the 1st of 1979. So again, not a new benefit. What the pension is, it is a needs-based guaranteed net income for wartime veterans and their surviving spouses. It's not a direct stipend. It's not an amount of money, excuse me, that the VA gives you because you served in wartime military. It's a needs-based program. So again, the needs is based on your net income. So it can be available to people who are in assisted living. It can be memory care. It can be nursing homes if you're private pay. And it can even take into account benefits if you are living at home and being cared for. Okay, so here's the rates. Now, these are the rates that are in current effect. Now, remember, these are monthly benefit rates. So, for example, let's look at a single veteran. To get the $1,911, and we'll talk about this in a little bit more detail in a second, the VA would add up the total gross monthly income of the veteran. So that would be Social Security, pensions, retirement, dividends, interest, you name it. They're going to add all that up. If that money is more than $1,911, ordinarily you wouldn't be eligible. you'd already be receiving more money than the program would guarantee you to receive. Remember, it's an income guarantee. But here's the big but. You're able to subtract from your benefit, your income, the cost of your room, board, and care in assisted living or memory care, what have you, plus any premiums that you pay for medical insurance. So let's say in this particular example that the cost of assisted living is more than that single veteran's income. So let's say they make $2,500 a month and it costs $3,500 to be in assisted living. The VA is going to look at that and say, well, sir, you're spending more than you make. So regardless of your gross income, after we subtract the cost of your care, your net income, what's left over, is zero. It's actually in the red, but VA is going to say it's zero. All right, because it's zero due to the medical expenses, you're guaranteed an income of $1,911. So that is the reason that the individual would get that particular amount of money. And that holds true whether if you're a married veteran, a single veteran, a surviving spouse of a veteran, and if you're both veterans, then that applies as well. There's 5 things you've got to prove to the VA. Now, ladies and gentlemen, I got to be honest with you, having done this for so long, I love pension claims. And here's why I do. It's because the evidence requirement is binary. And what I mean by that is it's either black or white. You can either prove something or you can't prove it. It's not subjective. Service-connected claims get to be a little bit subjective, but pension is not. It's the light switch is either on and you can prove something, or it's off and you can't prove it. So it's highly predictable. In other words, you can look at the evidence and very accurately predict what the VA is going to do in terms of the decision. And that's very helpful, of course. So there's 5 things that you got to prove. All right. Now, the very first one, and this is primarily the most important one. If you compare this to a baseball game, if you can't prove that you had honorable military service during an authorized period that Congress authorized, you're going to get thrown out running to first base. You won't even get to first base. So the very first thing we have to look at is the service period. Now, the authorized service periods are war periods. So right now there's 4 of them. There is World War II, and World War II starts at Pearl Harbor and ends on December 31st of 1946, not August of 45 when Japan surrendered, but the end of December 1946. The Korean period starts in the end of June of 1950 and goes to the end of January of 1955. Then you have the Korean period, or excuse me, the Vietnam period, which begins in 61 and goes through 75. And then you have the Middle Eastern Gulf War period, which started on August 2nd of 1990 and is still going on. They have not closed that window yet. To prove that you have service during those periods, we have to give the VA a copy of your military discharge. Has to prove 3 things: when you went in, when you got out, and the character of the discharge. So you have to have an honorable or equivalent discharge in order to be considered eligible for this benefit based on military service. If you do not have your military discharge papers, we may very well be able to help you get them. Okay, so that's something that we do to try to help our clients. All right, so that's number 1. All right, number 2 is marital status. Now, if you're married, the VA is going to pay you at a higher rate. So we give the VA evidence that you're married. Now, for surviving spouses, we have to prove that the widow is the veteran's surviving spouse. That simply means that you were married to the veteran when he or she died, and you have not remarried thereafter. If you divorce the veteran, you're not eligible. if the first husband or first spouse dies and you remarry, and the second spouse is not a veteran, you cannot claim benefits from the first marriage ordinarily. There is a very small 19-year window where that's not true, but it's very rare. Okay, so marital status is either proof of marriage, or if you're the surviving spouse, that you were married at the time of death and did not remarry. The primary evidence for marital status for a surviving spouse is a copy of the veteran's death certificate, because it shows that you were married at the time of death. All right, now, if we are going to ask the VA to add the special aid and attendance benefit, what we're going to do is we're going to go to your doctor, and the doctor is going to complete a 3-page, very high-level examination. And it's not a big clinical thing. What it's doing is saying, okay, what is the disability that's being discussed? And it can be dementia, it can be just general complications of old age, known as senescence. It could be any number of things. So there is a medical deficit that's occurring. Because of that medical deficit, a person is unable to safely undertake their normal daily activities, like getting around, incontinence, showering, bathing, dressing, grooming, taking medications as prescribed. Not necessarily that a person cannot do those things, but that it's not safe to do it by themselves. So if you think about the term aid and attendance, the VA is saying, give us medical evidence that shows that you need the help and presence, aid and attendance, you see, of another person to help you safely navigate those activities. That's what the medical report provides, is simply saying, here's what's going on medically, and here's why the person needs help in certain specific areas. If that is proven, the VA simply gives you more money. And that additional money is the special aid and attendance benefit. Okay, so the fourth bullet here is proof of limited net worth. All right, now why is net worth important? All right, remember, it's a needs-based program, right? It guarantees a certain amount of net monthly income. So the public law says that you have to prove limited net worth. All right, now that VA said, all right, Congress, you said limited net worth in the law. What we think you meant by that is a person's income and their assets. The first thing the VA is going to look at is net income. So they're going to add up the household. Now, important word there, household. If you're married, it's husband and wife, okay? So they're going to add up your Social Security, your pensions, your retirement, interest, dividends. If you get money in once a year from an IRA, they're going to divide it by 12. You get something in quarterly, they're going to divide it by 3. But they're going to get it down to a monthly gross income number. Now, from that income, you can subtract out-of-pocket predictable medical expenses. So that would be care, room and board, and medical insurance premiums. Now, the reason that it's kind of limited as to what you can deduct in terms of medical expenses is that word predictable. The VA says your income is predictable. We know you're going to get the same amount of Social Security every month. You're going to get the same amount of retirement every month. You know, within a few dollars, you're going to get the same IRA distribution or annuity distribution, what have you. So your income is predictable. So the VA wants to compare your predictable income with predictable medical expenses. Medical expenses that are going to be reasonably happening month after month after month. Now, I know what you're thinking. Well, does that include prescriptions and doctor's copays? It does not. And I agree with you if you're thinking, yeah, I'm on medications I'm going to be taking every day for the rest of my life. Me too, right? But the VA doesn't buy that argument. and I've been doing this, I'll tell you, I've been doing it so long, we don't even argue with the VA about that anymore. They're just not going to do it. So those two expenses there, the care, room and board, and the medical insurance premiums are what we can always deduct on the initial claim. Okay? So after a year, if you're not, this is kind of an aside, if you're not getting the maximum benefit and 12 months goes by, we can go back and ask the VA to increase your benefit. And if you bought a bucket, a rusty bucket for a medical expense, we can count the cost of that bucket. So after 12 months, we can, if you're not getting the maximum amount of money, we can go back and count everything that you spent in terms of medical expenses. Why? Because it's no longer predictable. It's historic at that point. All right, so your question is, why can't we do that on the initial claim? Because the law says we cannot count any out-of-pocket medical expense that you incurred prior to the date of claim. So anything before we file the claim, we can't count. But after a year, we can go back and count everything. So there is kind of an escape clause there, but not on the initial paperwork. So once we subtract the out-of-pocket cost, what's left is called net income for VA purposes. VA then pays you the difference between your household net income and the guaranteed monthly net income benefit. So here's two examples. First example would be you have income of $4,000 a month, you spend $45,000. All right, so you're upside down $500 a month to the negative. The VA would say your net income is zero. Here's the full amount of the monthly benefit. All right, same example. You make $4,000 a month, but you're only spending $3,500. So the VA says, okay, you've got $500 left over. So we're going to pay you the difference between the $500 you have left over and the amount of benefit that you're due. So if you're a surviving spouse and you have $500 left over and the benefit guarantees $1,228, they're going to pay you the difference between $500 and $1,228. That's how it works. Okay, so that is how net income. Now, if you do not have enough medical expense deductions to offset your income, then you would not be eligible because you're making more money than the problem or the person is guaranteed to receive in the pension. And by and large, that is, as I'm sure you guys will probably all nod up your heads up and down and agree, that's usually not a problem when it comes to assisted living. It's just the opposite problem. Okay, VA is going to look at all of a person's countable assets. So that's your bank accounts, your retirement accounts, investment accounts, property that you own at its fair market value other than your home, even if you're not living in your home and you still own it. Your home is an exempt asset. So we don't have to count the value of the home. If you own rental property or you own a vacation home or a lake home or what have you, any property or real estate that you own other than your home, we have to count at its fair market value. So the VA is going to add all of those assets together. All right, since October of 2018, you're allowed to have up to $129,094. So regardless of how old you are, if you're married or single, makes no difference. If you're below $129,094 in assets, you're perfectly okay. If you're $1 below that mark, you're okay. If you're $1 above that mark, you're not okay. It's just that straightforward. Now, that $129,094, it adjusts with cost of living every year, by the way. So it started out at $123,600 in October of 18, and it's now up to $129,094. So it does go up every year. However much your Social Security goes up, VA benefit goes up the same amount, and your net asset limit goes up. And by the way, the VA calls that 129,094. That's termed the bright line, BRIGHTLINE. So if you ever hear that term used, that is the bright line cutoff. Now, if you sell your home and convert it, then it's no longer exempt, and however much you net from the sale, we have to report to the VA. So if you start out owning the home and then 2 years down the road you sell it, we have to tell the VA about it. Now, the last bullet there is important. The VA does have a 3-year look-back period, and that means that you cannot transfer funds to create artificial eligibility. So if you've got more than 129, you can't give it away, you can't gift it, you can't transfer it, you can't buy an annuity. VA does not recognize trust. If you've ever been told that you can put it in an irrevocable trust, unfortunately, in law, that is just not true. You can put it in a trust, but the value of property or assets held in the trust have to be counted. It doesn't exempt it from being counted. So you can't move money around to create a situation where you're below the 129. If the VA catches you doing that, they can impose a penalty period of up to 5 years where you're not eligible to apply for benefits. So obviously it's not something that you want to do. Okay, so what do we do to help you get through that? Well, and you're probably thinking, boy, that sounds complicated. Well, it is, and that's why we exist. Our job is to take the complication out of it for you and to try to make this just as simple and painless as we possibly can. So we do that by offering 2 services. The first thing is we're going to do what is called a Prefiling Consultation. Now, so what we're going to do is we're going to go over those 5 eligibility requirements with you. We're just going to discuss them, and it's going to be kind of at a high level. For example, we're not going to talk about in detail what your income is. We're just going to say, for example, is it going to cost you more to live in assisted living or memory care or getting care at home than you make? And so we keep it at a real high level discussion initially. What we're trying to do in that initial discussion is, if we're going to hit a brick wall, let's hit it in the first 10 minutes of conversation, right? Don't go scurrying around trying to get a lot of paperwork together that's going to be irrelevant. We want to find out if you are in fact eligible to begin with. So if we're going to hit that wall, let's do it up front. So if we run into an obstacle that we can't deal with, we'll tell you what the problem is. That's the end of it. If we get through that preliminary discussion successfully, what we're going to say is, you know what? If we can prove with the applicable evidence needed to prove what we just talked about, you're going to get approximately so many dollars. So at that point, the client or potential client has a decision. Now, if they want to engage us and say, okay, hey guys, let's get started and move forward, we're going to take them by the hand in that pre-filing consultation, and we're going to help them get together just the information necessary to prove entitlement to the benefit. You don't have to worry about it. We're going to tell you exactly what we're looking for. We're going to take you by the hand and lead you through that process. What we're going to do once we get that evidence is very important. And I think this is probably one of the most important things we do for our clients, is we're going to review that evidence, and we're going to make sure to our satisfaction that that evidence actually proves that you're entitled. So we're going to look at the military papers. We're going to look at the doctor's papers. We're going to look at death certificates. We're going to look at bank statements and financial statements. And we're going to make sure that before we send any paper to the VA, that we feel professionally competent or convinced, rather, that based on our competency, that if we send that claim to the VA, the outcome is going to be an award. We will not file, excuse me, we will not file a claim with the VA that we cannot prove eligibility for. So if we don't have the evidence, that's the end of it. If we do, we're going to make sure that it's going to prove the point. Now, the way we stay in business, to be quite frank and honest with you, is we charge a small fee for a successful consultation. If we can't prove entitlement, there is no charge, no fee, no obligation, no anything. If you have actually paid the consultation fee, and as we are developing more of the paperwork, we discover something that causes us to change our mind about your eligibility, we will refund the consultation fee. So if we can't help you, we're certainly not going to hurt you. We do have to cover our costs. We are zero net profit. We do not profit from what we do, but all the employees here think for some odd reasons they should be paid every Friday. And the telephone company and the computer company feel like they should be paid too. So we have to have some way of meeting those obligations, and that is through the consultation fee. So if we can prove satisfactorily that a person is entitled, then that consultation fee is $800. And that's our break-even point. Okay, we don't, like I said, we don't profit, but we cover our actual cost. So that's how the consultation works. All right, so once we get through the consultation, so we've talked about it, we've gotten the evidence, we've evaluated the evidence, we are convinced that everything is a go, we go to step 2. Step 2 is lifetime representation. The important thing about this is there is absolutely no fee charge whatsoever for our representation, and that is for lifetime. So we don't throw paperwork at the VA and wish it well, and that's the end of it. We work with our client and stay involved with our client for the rest of their lives. There is no fee or charge for the representation. That means that we prepare all of the VA paperwork for you. We submit the claim as a fully developed claim. That simply means it's complete for adjudication. And then we proactively prosecute the claim until it's awarded accurately. So we prepare the paperwork, we give it to the VA, we stay with it till it's awarded properly. Then if anything else comes up regarding that claim for the remainder of our client's life, you don't call the VA, you call us, and we take care of it for you. And there's no fee or charge for any of the representation. Okay, and so how you get started, real simple. You make a phone call to us. You don't need an appointment. The interview's on a very high level, so you don't need a lot of to the right of the decimal point type of information. What we're going to do is high-level review and just make sure we think we have a case. If you decide that you want to engage us, we're going to take you by the hand, as I said earlier, and get you through it just as quickly and painlessly as it possibly can be done. Now, the families are the people who know the information. We're simply going to tell them what information we need, and if they need help obtaining it, like getting copies of military records from the National Archives, we will help them get through that. We'll do it for them, basically. So the idea is that when that claim goes to the VA, it's going to be so compelling and persuasive that the VA is going to award the benefit. And to be honest with you, I can't remember the last time people often ask us, well, what's your success rate? Well, it's right at 100%. I mean, it's not perfect 100% because there's things that happen, but it's 99.99999% because we won't file the claim to start with. We can't prove it. So if we send it to the VA, we fully expect that claim to be awarded. And that's what happens. Okay. So just as a first step here, and this is very applicable because of the time of the month it is. The VA pays retroactively on claims. It pays retroactively to the first of the month after they get an initial piece of paperwork called a notice of intent. That simply means if we filed a very simple set of forms, which takes about 10 minutes to do, between now and Friday at the end of work, the VA would pay a person back to August the 1st and you wouldn't lose any money. So our usual protocol is to file the notice of intent on all of our claims, so that even if you're having to take time, for example, maybe the doctor's not getting your paperwork back for the aid and attendance part of it very quickly, we file the notice of intent, which ensures they don't lose any money. And so that's our normal protocol. So that's the first step that we would do, is simply, and it's a very simple 10-minute process. In some cases, we can even do it over the phone with the VA. So that's the first step. That just locks everything down and makes sure that no money is lost. Okay, so here's some frequently asked questions. How long does this process take? Right now, pension claims are taking, we see 2.5 to 6 months is what's on that slide. Right now, the average is about 60 to 70 days. About 20% of the claims that we're filing for pension are getting done in 2 to 3 weeks. And the answer, question is, well, why is it going that fast? Because the VA mandated a ton of overtime. You've got people working weekends, at nights, and they are busting their behinds to get paperwork done. So we're seeing very fast turnarounds right now on average. There are no other fees. Yes, we'll help you get the discharge papers. And if you want us to follow up on what's going on with your claim, you can call us. We will call the VA. We'll get a status of where that claim is at that moment, and we will call you right back, and we'll tell you exactly where it is and how long we think it's going to take for it to be completed.